Good afternoon, members. I am on my own in the meeting room today, but I am joined by Alex Easton virtually, Pat Sheehan, Pádraig Delargy and Emma Sheeran. Also, I have been delegated Trevor Lunn's vote and also John Stewart's vote. John may get to join us at some point later on this afternoon, but if he isn't, I've got his vote. Okay, in relation to Chairperson's business, item number 2, members, you will note that the official apology to victims and survivors of the historical institutional abuse took place on Friday, the 11th of March. And I suppose I was present up in the Long Gallery and I viewed all of the proceedings that morning. It was pretty sombre that afternoon, actually. It was pretty sombre. But there was really broad agreement, I would say, from all of the victims and survivors that the Minister's statements and apology, the state apology, was pitched, I suppose, in the right way with the right words. And survivor groups recognised that and were very appreciative. I have to say that survivor groups then did express to me that they had reservations about some of the statements from the institutions, and that is a bit regrettable. John Stewart and I spoke about it as we were both present, and we did feel that there was, I suppose, a lightness and not a full and wholesome apology that the victims and survivors had expected. But that's my personal view. However, I did speak to Fiona Ryan afterwards, and she was discussing, the details with the victims and survivors, and I'm sure if she has any issues to raise, that she'll get back to us in the next week or so. Have any other members anything that they'd like to add to that? Have they been contacted with any of the victim survivor groups at all?
Yeah, could I come in there?
Yes.
Just to concur with what you said yourself, I think most of the victims and survivors I spoke to were happy with the apology from the ministers. But there was, let's just say, thought that the apology from the institutions was less than satisfactory. So I'm just putting that on the record. Thanks.
Okay. So item number 2 in Chair's business. Can I just report that the Fair Employment Schools Teachers Bill was published on the 11th of March, and a copy was sent to all members. The bill has had its consideration stage yesterday, and some of you spoke on that. The committee amendment extending commencement from 12 months to 24 months was made. Further consideration stage is scheduled for this Monday, the 21st of March, and the final stage is scheduled for Thursday, the 24th. Obviously, the times that are very predictive now at the moment. It's a very, very evolving timetable for the end stages of this mandate. But it was great to get to the consideration stage yesterday. Members also, last week we all expressed our concerns in relation to the situation in Ukraine and for the plight of refugees from the conflict. And we sought an update from the Executive Office in relation to the Northern Ireland response. To date, we've actually heard nothing from the department, but I've learned that apparently there is a response, but it hasn't been signed off yet. Despite communications been made to the press and obviously pronouncements been made in the floor of the House of Commons, we as a committee have actually heard no details of what the response is. So what our understanding is, and my understanding from the public announcements, is that it is going to be led and coordinated by the head of the Civil Service, Jane Brady. But to say I'm disappointed at the department and the officials is probably a very slight way of saying it. You know, I do think that this committee deserves the respect to actually have a full, detailed outline of what the response is from Northern Ireland for refugees arriving here, and hopefully, maybe even by close of business today, we will hear something from the Executive Office. But in the absence of that, can I seek your agreement that we invite the Head of the Civil Service to attend the committee next week to give us a full briefing of preparations that are taking place to welcome refugees into Northern Ireland? Yes? Okay.
Yes.
Right.
Excellent.
Also, members, if you remember, the committee wrote to Queen's University School of Medicine asking particular questions in relation to the acquisition of bodies from the institutions identified in research on the mother and baby homes. We have been informed by Queen's that a reply, again, has been drafted but not signed off. I was hoping that we would have it in our packs this week, but unfortunately we haven't. So can I propose that we write again to Queen's University asking them to finalise the response and accelerate its submission so that we have it in our packs in time for discussion next week. And also, on receipt of that reply, can I also suggest to members that the committee issues a press release on this issue to be agreed at next week's meeting, highlighting the importance for victims and survivors of a thorough examination of this sensitive issue to be undertaken. And finally, can I also suggest to members that it is raised with the successor committee in the legacy report. I think it's important when we ask for information that we actually have a follow through and a pathway for dealing with the response. Agreed. Agreed. Okay. Item number 3, draft minutes. Members, the draft minutes of the meeting held on the 11th of March are on pages 5 to 10 of the meeting pack. If you're content with the minutes, that the minutes are a true reflection, I'm happy to sign. Item number 4, matters arising. Members, a summary report of the stakeholder session on the 24th of March on the violence against women and girls strategy can be found on the pages between 12 and 14 of the meeting pack. And I think it's important just to state the key findings in that report, just for the open record. Just a summary of the key findings. It indicated that engagement needs to be early, meaningful and open-minded. More vulnerable groups such as LGBTB people, disabled people, minority ethnic identities need to be engaged with and protected in the strategy. Violence against women and girls is the consequence of misogyny. This needs to be acknowledged and to be addressed. So the title of the strategy should be Male or Men's Violence Against Women and Girls. And the 4th recommendation summary was women's organisations need to be resourced to address the impacts of male violence, assist in addressing such violence and have a role in monitoring progress. So if members are happy with the report, can we forward that summary to the Executive Office for consideration? Okay, thank you. Matters arising, item number 2. Members, the House of Commons Northern Ireland Affairs Committee have produced a report on the experiences of minority, ethnic and migrant people in Northern Ireland. If I refer you to pages 15 to 41 of the meeting pack for relevant papers, some of the statistics in the report are deeply troubling, obviously, and must be addressed with utmost seriousness and urgency by the Executive Office and by all other departments actually as well. The report highlights the work of the Northern Ireland Office and the UK Government in this area, and as some of the policy areas overlap to the department, the Northern Ireland Affairs Committee has asked that the Executive Office reply to the report and set out its responses to its findings, as well as an update on recent progress made in this policy area. I think it's a really important report as well. Even on the back of us now about to welcome Ukrainian refugees, there are some real key findings here, and it's important that we know what they are, and areas of good practice and areas of poor practice that we've experienced in Northern Ireland to date, and try to do some remedial actions before Ukrainian refugees come. So if members are happy enough that we will endorse that report and ask that the Executive Office responds to it within 3 months as requested within the body of the report. Okay. Item number 5, Northern Ireland Assembly EU Affairs Manager Shauna Mageean is coming to the meeting this afternoon to give us an overview of the Assembly EU Affairs to date. If I can refer to pages 42, 77 of the meeting pack for the relevant papers, this it will be videoed of the meeting and will be available on the committee webpage. So can I invite Shauna to address the committee? You're all silent. Great.
That must be the catchphrase for the last 2 years. Thanks very much, Chair. Obviously you've got the paper in the pack. I propose I'll just pick out some key points from it. I'm not going to go through the whole thing. And also I know that this paper was from a couple of weeks ago, so there's a couple of other developments I just would want to draw the committee's attention to. So if you're content, Chair, then I'll just go through some key points here. So obviously, since I was last at the committee, the negotiations between the UK and the EU have been continuing, with Liz Truss in charge of the Brexit portfolio since the end of 2021. So she's held a number of in-person meetings and telephone calls with the Commission Vice President, Maros Šefčovič. Writing prior to her first formal meeting with Mr Šefčovič, Liz Truss said that her absolute priority was to deal with the issues in the protocol that could threaten the hard-won gains of the Good Friday Agreement. The UK's solution essentially proposes that a lot of goods going to the EU shouldn't have to go through customs formalities, and that they should go through customs formalities, but those goods that are staying in Northern Ireland shouldn't have to. Truss emphasised that the UK wants a negotiated solution, but that the UK is willing to use Article 16. Šefčovič has since said that he has an excellent working relationship with the Foreign Secretary, and he does appreciate the personal involvement and investment that she is putting into the issues. And indeed, we've seen a number of joint statements following their meetings, which we haven't had since going back to Michael Gove's time when he was handling the Brexit portfolio. Šefčovič briefed members of the European Parliament back in January, signalling that the negotiations could wrap up by the end of February at that time, because there was an understanding there'd have to be a pause or a change of pace because of the upcoming Assembly elections. He said that the UK are our neighbours, our allies, and I think all of us in this House would like to see them again as our strategic partners. For that to happen, we need to rebuild the trust, and trust is built by respecting our agreements. Speaking on trade between the GBNI and the EU and engagement with businesses on the protocol, the Secretary of State Brandon Lewis said that businesses are very clear that the protocol in its current format is not working, it is not sustainable, the EU offer is not good enough. They are very clear about that. That is something we are determined to fix. If the protocol works in the way it was envisaged, it does create opportunities for Northern Ireland. The problem is that the EU's requirements for implementation are failing Northern Ireland, and we do need to see that fixed. Prime Minister Boris Johnson told the House of Commons that he never thought when they negotiated the protocol that it would mean 200 businesses would stop supplying Northern Ireland, foods being blocked and Christmas cards being surcharged. He said the EU is implementing the protocol in an insane and pettifogging way. And again, Boris Johnson said that on the protocol, it doesn't require, contrary to how it is being applied by our friends, for all foods and all medicines and all plants to be systematically checked in the way they are. They must fix it, and with goodwill and common sense, I believe we can. However, if our friends do not show the requisite common sense, we will of course trigger Article 16. So in relation to the governance structures of the withdrawal agreement, the Specialised Committee on Citizens' Rights met in January, and they produced a joint statement and published their joint report on residence. And the Joint Committee met on the 21st of February in Brussels. This was the first formal meeting of the Joint Committee since June 2021, but obviously Šefčovič and Truss have been having a number of other meetings, but this was the first formal meeting of the Joint Committee since last June. And on the agenda was the protocol, citizens' rights, and the stock take of the other specialised committees established by the withdrawal agreement. Again, there was a joint statement released following the meeting, and both parties underlined the ongoing determination to ensure that the outstanding issues in the context of the protocol are addressed. Interestingly, Vice President Shevchevich and the Foreign Secretary also reiterated the importance of further engagement, including with the Northern Ireland Assembly and Executive and with wider Northern Ireland civic society and business. Shevchevich described the talks as neither a breakdown nor a breakthrough. So there was lots of discussion about what was going to happen then in the run-up to the Assembly elections, and an unnamed official suggested that talks will happen in a more discreet way, so there'd be less regular formal meetings, but perhaps more technical meetings behind the scenes between officials. There's some discussion about the customs paperwork and how to reduce the burden. You may well have already heard the talk about the EU has said they want to reduce the number of data fields on customs declarations, but they said they need customs codes to give a greater level of detail, because the UK said if they can use custom codes which would describe the goods in high-level terms, that would be sufficient. The EU said they need a greater level of detail, and the example they gave is in respect of a product like olive oil, because some types of olive oil are clearly used for consumption in restaurants and supermarkets, but other grades of olive oil are used for food processing. So they said that's an example of why they need greater detail. But there's also been progress on access to UK customs databases, and I had briefed the committee on that previously, that was long requested by the EU, so they could have more fulsome access to customs databases, more access to real-time information, and there seems to have been progress on that. A meeting of the Specialised Committee took place last week, the Specialised Committee on the implementation of the protocol. The committee took stock of progress in relation to the protocol, and in a joint statement afterwards said that both parties underlined their ongoing determination to ensure that outstanding issues are addressed. They also took stock of the work of the Joint Consultative Working Group, and reiterated the importance of further engagement. So moving on then, the House of Lords Subcommittee on the Protocol launched an inquiry in January into the role of the Court of Justice in the EU, and has been holding a number of evidence sessions with stakeholders and experts on that. Lots of discussion around the role of the ECJ and how that compares to other treaties. One expert, a QC, said that it's contrary to international treaty practice for one party to have their own domestic court to be binding on the other. There was an acknowledgement from stakeholders that the dispute mechanisms in the protocol are highly unusual, but that the protocol and the withdrawal agreement are unusual in themselves. The EU perspective, said one stakeholder, is that they are EU rules, so it must be the EU court that has oversight. There was an argument that the government has moved away from arguing for no role whatsoever for the ECJ to a more residual role, and a QC suggested the current provisions regards dispute resolution should be replaced with, or could be replaced with, what is already in the Trade and Cooperation Agreement around arbitration. So the committee has written to Liz Truss, setting out its analysis of the role of the ECJ, with a number of questions, including whether and how the Northern Ireland Executive can play an explicit role in dialogue to resolve disputes in relation to the protocol. That subcommittee has also written to Liz Truss regarding the committee's scrutiny of EU legislation which falls within the scope of the protocol, saying that since the committee was established, it has written over 80 letters to government ministers on 40 separate EU legislative proposals applying or potentially applying to Northern Ireland under the terms of the protocol. The committee was very critical of the quality and consistency of the UK government's explanatory memoranda on this EU legislation applying to Northern Ireland. They have also been seeking the government's analysis on the EU proposals on medicines, which members will recall from December. And in the Assembly chamber, their Minister for Health, Robin Swan, was asked for his assessment of the impact of the protocol in respect of medicine supplies to Northern Ireland. He said that his officials have examined the text from the EU proposals in December and said there are a number of areas which require clarification to be able to ascertain the long-term implications in relation to medicines supply. On controls on animals and goods, the Department for Agriculture, Environment and Rural Affairs, DERA, laid in the Assembly Library at the end of January, laid a copy of the European Commission's audit of controls on animals and goods entering Northern Ireland and on border control posts. So this was a review that the European Commission carried out in June 2021. And the Commission's report concludes that the system is not fit for purpose, does not comply with EU rules, and cannot provide sufficient assurances that only compliant animals and goods are permitted to enter the EU sanitary and phytosanitary area through the designated border control posts in Northern Ireland. It highlights that the UK government has failed to ensure that sufficient resources, both human and structural resources, have been made available to the responsible competent authorities in Northern Ireland by the devolved administration in Northern Ireland, which, by virtue of the decisions it has taken on halting the recruitment of staff and stopping the development of border control post infrastructure, is impeding the full implementation of the protocol. So that report makes a number of recommendations to address the shortcomings it found, and the competent authorities have been invited to provide details of the action plans, including a deadline for completion within 25 days of receipt of this report. So the competent authorities are obviously DERA, but also DEFRA, HMRC, and the Food Standards Authority, or Food Standards Agency, district councils. And I understand the ERA committee is in correspondence with the department on those follow-up action plans. And speaking in the chamber, the DERA minister was asked to outline the impact on the agri-food sector of the full implementation of the protocol. And he said that even with the grace periods, the points of entry are currently processing in excess of 2,500 common health entry certificates, or CHEDs, per week, and over 10,000 per month. Approximately 90% of those CHEDs relate to products of animal origin, and they must be validated and recorded by a departmental official vet, which is a complete waste of their time. In addition, each consignment that is covered by a CHED requires an identity check, and EU law dictates that a range of physical checks are also required, with frequency depending on the type of consignment. Where the grace period is not in place, it is estimated that Northern Ireland's point of entry would be required to process in excess of 12,500 CHEDs per week. The Secretary of State also took some questions on the possibility of a veterinary agreement, a veterinary and SPS agreement between the UK and the EU. He said that the UK has put forward proposals, such as Green Channel proposals, which would deal more easily with East-West customs. And this is an area where he wants to see some more flexibility from the European Union. There's been some polling on the protocol since I was at committee last. So Manufacturing NI in January published the result of its surveys of traders' experience on the protocol 1 year since it came into operation. Almost 60% of manufacturers reported that access to labour is their biggest issue. The survey finds that some firms continue to struggle with the new requirements in the Irish Sea, but that has decreased since earlier last year. The report did highlight a lack of preparedness both at government and business level for what was introduced in January 2021. And the report does note that the EU GB import controls are now starting to be implemented, and it could be the case that as more GB traders become experienced in customs formalities, they may be willing to send goods to Northern Ireland. And then February, Queen's University published the results of its latest poll, which is the fourth one since March 21, on the protocol as part of its post-Brexit Governance Northern Ireland project. And shows that opinion among voters continues to be deeply divided, with 50% agreeing or strongly agreeing that the protocol is, on balance, a good thing for Northern Ireland, while 41% disagree. 75% of respondents are concerned about this supply of medicines, while 66% are concerned about the lack of involvement of elected representatives, officials and civic society in the governance of the protocol. On the Trade and Cooperation Agreement, then the various specialised committees established by the TCA haven't been meeting, and officials from Northern Ireland Executive Departments have been in attendance at those meetings. The Lords European Affairs Committee recently wrote to Liz Truss about UK participation in the Horizon Europe programme, saying that they think that the UK and the EU have been treating association to Horizon Europe as a bargaining chip in context of the wider political disputes, especially around negotiations around the protocol. Under the TCA, members will be aware, obviously, there's a Parliamentary Partnership Assembly, was one of the bodies established by the TCA, and in January, the Prime Minister made a written statement naming the UK delegation to that UK-EU body. The PPA is a forum for the UK Parliament and the European Parliament to exchange views on the TCA. There are 21 members from the Commons and 14 from the Lords in the UK delegation, and there are 12 substitutes. Sir Geoffrey Donaldson is a full member and Baroness Ritchie is a substitute. And that delegation has had its inaugural meeting and met in February. Sir Oliver Heald is the chair and Lord Connaught and Hilary Benn are the vice chairs. And at their first meeting of that delegation, the UK delegation confirmed support for securing observer status for the Assembly and the other devolved legislatures in meeting of the PPA, but that would have to be agreed with the European Parliament. There's no date yet for that inaugural meeting of the PPA as a whole between the UK and the EU. It was anticipated that it would be May, June time, so I haven't heard anything more concrete on that. So common frameworks then, Chair, really the committee will be very familiar with these, but they aim to ensure a common approach is taken in areas previously governed by EU law. Neil O'Brien, who is the Parliamentary Under-Secretary of State for Levelling Up the Union and Constitution, has taken over the role with the responsibility for common frameworks. And members will know there are 32 policy areas where frameworks are required relating to Northern Ireland. But the programme has been repeatedly delayed, and the latest time frame was that the governments had all agreed they would try and ensure that all the scrutiny of common frameworks had taken place prior to the pre-election period in Northern Ireland. However, it appears again that there's some slippage in this now. A DEFRA official told the the House of Lords Common Frameworks Committee that if the frameworks weren't agreed by the dissolution of the Assembly, there is a contingency plan and the frameworks would be operated on an interim basis as they are currently. He said that if the executive didn't return for a longer time, more detailed work would be required. Under the frameworks as well, there is a provision for each government to propose an exclusion from the common frameworks for exclusion in common framework areas under the internal market, and Scotland has proposed to ban single-use plastics, so that will be one test for the Internal Market Act and its relationship with common frameworks. The Assembly committees obviously continue to scrutinise common frameworks in the Committee for Economy. They've been briefed on the late payments common framework and the company law common framework. On potential divergence within the UK on these issues, economy officials said they are trying to tease out what the potential implications would be, because divergence is a very live issue for the department, particularly with regard to the protocol and Northern Ireland's obligations to follow EU law. So it's quite difficult to see what the implications will be, and that was echoed by the officials. The ERA committee have been busy scrutinising 9 common frameworks falling under their remit, which have been published. Animal health and welfare was a big one. They took a lot of evidence from those, and again, the principle of how to deal with future divergence was raised by a lot of the stakeholders. The UFU, for example, said on animal welfare standards that we could see a position where there's divergence in welfare standard, regardless of the perceived or actual welfare gains or benefits to animals. You could see a situation where farmers within Northern Ireland are going to have a differing level of standard to adhere to, and they think that it would be important that there's a collaboration across the 4 nations to ensure that everybody is on a level playing field. And again, on fertilisers, the stakeholders said in principle they were content, but the devil is in the detail. And again, differing regulations between Northern Ireland, the Republic of Ireland and GB on something like fertilisers could be challenging. The Agriculture Support Common Framework also has been published. And again, the stakeholders looking for more detail, generally content, but looking for more detail. And again, chemicals and pesticides, it's another one that they were looking at. Also, plant health and plant varieties and seeds, and members will have been aware about challenges certainly in importation of plants and seed potatoes and things like that coming from NI to GB. So the stakeholders said that those issues are not only affecting big farmers but also small consumers. So that committee has been very busy with a wide range of common frameworks to look at. Moving on to legislation then, the Subsidy Control Bill awaits report stage in the House of Lords, and members will be aware that that bill will establish a new UK framework for subsidies in place of the EU state aid rules. However, Article 10 of the protocol says that EU state aid rules will continue to apply in respect of trade between Northern Ireland and the EU. The House of Lords Subcommittee on the Protocol has written to the Government on the Subsidy Control Bill, seeking a further assessment of the impact on Northern Ireland, especially in relation to the ability to attract foreign and direct investment. The Nationality and Borders Bill is now at ping-pong stage, i.e. The House of Commons and the House of Lords are considering each other's amendments. The bill requires non-Irish EU nationals will need an electronic travel authorisation to travel to Northern Ireland, but the Home Office has stated there will not be routine controls conducted in the common travel area and there will be no immigration controls on the land border. The Protocol Committee, Subcommittee in the Lords has written to the Government saying it is clearly unsatisfactory for significant details such as the electronic travel authorisation scheme to remain unclear prior to completion of the parliamentary passage of the bill, and they want some more information about how it will work within the common travel area. And the Human Rights Commission and the Equality Commission have called for Northern Ireland to be removed from the modern slavery and human trafficking provisions of that bill, because they're concerned it does potentially breach Article 2 of the protocol. The Prime Minister has announced a Brexit freedom bill, which brought forward to will mark the 2-year anniversary of getting Brexit done and will end the special status of EU law and ensure it can be more easily amended. On free trade agreements, the UK-Australia free trade agreement was debated in the Commons in January, and the Government assesses that the FTA could result in an increase in gross value added product in Northern Ireland of 21 million. The Department for Economy submitted evidence to the Commons Trade Committee inquiry on that particular FTA and stated that it does not deliver on UK interests as sensitive agriculture sectors are not given sufficient protection from imports. And ultimately, the interaction between the provisions of the FTAs and Northern Ireland's legal obligations under the protocol are complex and create uncertainty. The Minister for Agriculture, Environment and Rural Affairs also said that his view was that the FTAs with New Zealand and Australia will offer little benefit to Northern Ireland's agricultural exporters, as those particular countries have a considerable advantage in those sectors. Nancy Pelosi also visited London in February and was asked about future trade deals between the UK and the United States. And she said, our relationship and trade is dependent on how the Brexit Accords are resolved. She said she reiterated that she told Boris Johnson not to expect a bilateral trade agreement if there's an unravelling of the Good Friday Accord in relation to the border. The government signed an FTA with New Zealand on the 28th of February, and they said that their trade relationship is expected to be boosted by 60%. On benefits of Brexit, the government has published a report on the benefits of Brexit and set out achievements to date, how regulation will be reformed, and the government's vision for future policy areas. The report also discussed the review and amending of retained EU law, which has the handy acronym of RULE, R-E-U-L. So EU law was essentially transferred onto the statute book after Brexit. It was like a giant cut and paste exercise to create legal certainty in the statute book in that short period of time. But the Commons European Scrutiny Committee is doing an inquiry into the future of retained EU law, and obviously that does tie up with the Brexit Freedoms Bill, because that does look at ending the status of special status of retained EU law. Sir Bill Cash, who is the chair of that particular committee, said that the UK's withdrawal from the EU and consequent changes made to the legal system amount to a legal revolution, and there was lots of discussion about the importance of parliamentary scrutiny of retained EU law and any changes to that as well. On intergovernmental relations then, Chair, the government has published its conclusions of its review of intergovernmental relations, and that was a review carried out jointly with the devolved governments. And this was essentially going to replace the old Joint Ministerial Committee, or JMC, structures that the members will have been previously familiar with. It creates a new 3-tier structure of engagement with the Prime Minister and heads of devolved government council at the top. The second tier is then a range of interministerial standing committees, and then a number of interministerial groups will represent the third tier. And there's also some new mechanisms for dispute resolution. At the end of February, the House of Lords hosted the first meeting of the Inter-Parliamentary Forum, and yourself, Chair, obviously, and the Chair of the Economy Committee were in attendance at that. And that forum also heard from Neil O'Brien, the aforementioned Minister who has responsibility for common frameworks. BIPA, the British Irish Parliamentary Assembly, met in Westminster in February. James Cleverly and Thomas Byrne, the respective ministers with responsibility for the European portfolio, briefed the BIPA. Mr Cleverly did acknowledge that opportunities for informal bilateral talks between the UK and Ireland have become rarer since Brexit. He said that having chosen to step out of the EU, the UK has a real responsibility to make sure we replicate the level of bilateral engagement that the EU would have previously provided. And finally, Chair, just a couple of very quick points on other news. Just to note, France took over the presidency of the European Council in January, and in its presidency programme, it stated that it will ensure that the unity of member states is preserved and that the UK respects its commitments, in particular on the protocol. The UK government has published its explanatory memoranda on the EU proposals in respect of the regulations of medicines in Northern Ireland. It states that the government is working to fully scrutinise the legislative proposals to determine the extent to which they do address the concerns that industry stakeholders have raised. So the European Council has agreed the mandate for these new regulations, so it's in the hands of the European Parliament now to move that directive and make it into force, bring it into force as soon as possible. The Commons European Scrutiny Committee has been scrutinising that particular explanatory memoranda and has written to the government on it to clarify the situation, because it says there remains a risk that the same medicines will not be available in GB and NI in the event that the EU and GB regulators may take different views. They also asked whether the government accepts that the proposal does place constraints on the UK's regulatory autonomy, suggesting that the UK will have to be mindful of EU law in exercising regulatory autonomy in this area. And the Cross-Party and Cross-Industry UK Trade and Business Commission has published its annual report, which makes a number of recommendations to improve cooperation and trade between the UK and the EU. One of which is their recommendations is a comprehensive veterinary agreement to resolve some of the SPS check areas. And then finally, members will have been aware of the decision of the Court of Appeal in respect of the challenge to the protocol, and the judgment is available online. So, Chair, that was a run through of the paper. I hope that wasn't too long. So, very happy to take any questions about any aspects of that or follow up with members afterwards if there's further information they require.
Okay, Shauna, you can take a small breath now after all of that. That was an extremely thorough summation of what has been taking place in the last few months. And I suppose one of the reflections that I would make just on that report is a couple of months changes everything, doesn't it? We started off the report reflecting on the new relationships between the EU and the UK because of new appointments, and Liz Truss in particular, and the warmth of that relationship compared to the previous relationship with the UK negotiator. And obviously things were moving, and whilst there wasn't an awful lot of pronouncements been made, you had a sense that things were moving forward. But there was that element of Article 16 hanging over, and the threat of triggering Article 16 in the last few weeks. There's been no mention of it at all. The global issues have come to the fore, and obviously that EU-UK negotiations, relationships have moved into a different footing and different prioritisation, which is interesting in itself as well, which might give a space for some of the work that is currently taken. But what I would reflect on as well is just the complexity of the issues that you've outlined there, and you know, the pace in which we need answers and to move it forward for various different sectors and various different departments. But it's important that we have some stabilisation in relation to the trading environment, and that there is a willingness on the UK and the EU's side to resolve these issues. And your report, when you see it all collated together about what has been happening in the last few months, like literally, from this is a summation really of what maybe December right to now. There's been an awful lot of work taking place, so hopefully at some point perhaps At this point, it'll be after the elections that we'll move into a more stabilised environment where the protocol is working the way we all envisage it to work. And to the satisfaction of everyone else, which would be really helpful. But just on that, Shauna, do you think that there's any evidence that the transfer of responsibility for negotiations with the EU being transferred to the Foreign, Commonwealth and Development Office has had an impact on the relationship with the EU? You know, as I say, it feels like it has, but what's your understanding from keeping a very close eye on these things?
I think that, as you say, Chair, it was a new development to move this particular portfolio over to the Foreign Office. But there have been a number of changes, obviously, since the portfolio was created. Members will remember the Department for Exiting the EU back in the day, and there have been a number of changes as to how the Brexit negotiations are handled and with whose portfolio that sits. I mean, I can only reflect on, as I say, Šefčovič has openly spoken about the good working relationship he has with the Foreign Secretary. You know, obviously, sometimes it's down to personalities. But I would say then also, from the outside looking in, you could see that perhaps it does demonstrate, the current situation does demonstrate that if you have what is quite a complex and time-consuming portfolio within an existing very large portfolio like that of the Foreign Secretary, it would be challenging, especially when there's other global developments taking place, such as Ukraine, which you can imagine would take up significant bandwidth within the department, both of the Foreign Secretary and her advisors and the other staff. So there have been a number of changes as to where Brexit sits, and who knows if it will remain within the Foreign Secretary's portfolio. I would imagine that she has a lot on her plate, but remains to be seen. As I say, you know, you can read a lot into media reports and things. All I can say is we do have joint statements coming from Mr. Šefčovič and the Foreign Secretary. So whether that is a reflection of a good working relationship or not, I guess, is open to interpretation.
And just on that, in relation to the Joint Committee, we had the first Joint Committee meeting there in February. What do you think the effect is of the infrequency of these joint committees, particularly on the voice of Northern Ireland and the you know, that democratic position for Northern Ireland? And I mean, it was regrettable that we didn't have our First Minister and Deputy First Minister being part of that joint committee. But what impact do you think that has in our democratic voice?
I guess, obviously, the Joint Committee meeting, there hadn't been a meeting since June last year. But to be fair, as members will know, there's a sort of three-tier governance structure for the withdrawal agreement. The Specialised Committee, and then the Joint Consultative Working Group. Now, the Joint Consultative Working Group is meeting regularly. It meets once a month, I understand. And I guess that's where a lot of the technical detail is discussed between officials. So while the Joint Committee wasn't meeting, that's not to say that the work wasn't going on in terms of the more technical talks between officials, very much into the detail and the nuts and bolts. But from the Assembly's point of view, and obviously from a transparency and accountability point of view, as we know, those particular meetings of the Joint Consultative Working Group are between officials, and there aren't any joint statements or anything of that nature that come from those meetings. So the Joint Committee at the top level of the tier of governance does provide a bit more transparency about what's discussed. So we would miss that transparency if the Joint Committee isn't meeting, but that's not to say, as I say, that there's not meetings going on behind the scenes between officials where a lot of the technical detail would be gone into.
Just now that you're talking about technical detail, what happens to the common frameworks if they're not scrutinised by the Assembly by the end of the mandate? What's the next steps? Well,
the governments had all agreed that they would set the deadline of the pre-election period, so i.e. before the Assembly dissolves for the election. But the contingency plan is that if they're not scrutinised and the process completed by that stage, that the frameworks will operate on a provisional basis, on an interim basis, as they indeed are at the minute. So in theory, there shouldn't be any gaps or problems for stakeholders or operators or a business in those. They will continue to operate on an interim basis. However, it obviously does mean that parliamentary scrutiny hasn't happened and that final sign-off hasn't happened. So we could potentially see that the process for agreeing the common frameworks will move into the next Assembly mandate. And indeed, there's two common frameworks, I think, within the economy remit that we don't expect to see until autumn. Mutual recognition of professional qualifications being one of them, and goods and services being the other. So it is likely that the process for scrutiny of common frameworks is going to move into the next Assembly mandate.
Well, if it's any consolation, the other devolved governments are finding, the scrutinising of the common frameworks as difficult as well. So, Shauna, thank you very, very much for your briefing today. And I'm going to now open it up and ask Pat Sheehan to come into the spotlight, please.
Hey, Shauna, thanks for that very comprehensive report. Just a quick question. I suppose I'm looking more for your opinion than anything else. Given that the talks seem to have slowed down a bit in the run-up to the elections, you've also the situation in Ukraine, and you talked about the sort of bandwidth that would, that the foreign minister would have, and it might sort of go outside of her remit in terms of negotiating around the protocol. But there's also the issue that Britain at the minute may not want to get into a trade war in the middle of this crisis in Ukraine as a result of the Russian invasion. And then on top of all of that, you had the court verdict in Belfast this week, which reaffirmed the lawfulness of the protocol. Is there some suggestion in all of that the sort of crisis around the protocol in British politics anyway is being downgraded, do you think?
It's difficult for me to obviously answer, but it's a quite political question, Pat. But I mean, I think that you can definitely see, naturally enough, that the war in Ukraine and those developments are going to take a lot of attention and bandwidth within the departments. I think that's a reasonable conclusion you would draw, that the Foreign Office is obviously going to be very actively involved in the UK response to that war. I mean, there are intimations, as I say, from media reports that the talks are still continuing between officials in respect of they may well have slowed down in terms of the public meetings between Shevchevich and the Foreign Secretary, but the discussions are still very much ongoing between officials and on an official level when it comes to the outstanding areas of difference on the protocol. So I think it would be wrong to draw a conclusion that those talks have stopped or paused in any way. The public face of them may well have paused. But I certainly would doubt that that's the case at official level. But I mean, in terms of the position of the protocol as a priority issue, I think that's a question for somebody else other than me. But
Okay, Sean, I wasn't trying to put you on the spot. Thanks for that.
Good sidestep there, Shauna. Can I bring Diane Dodds into the spotlight, please?
Hi, Shauna. How are you? Good to see you again.
Thank you.
Good. So I just have a couple of sort of quick questions.
Sure.
And maybe some actions that we as a committee could take. So I noticed that the European Scrutiny Committee had done some work on the issue of medicines and the supply of medicines to Northern Ireland.
Yep.
And one of the issues that they were very concerned about was the issue of new medicines. In other words, so a drug is licensed in the UK, it could come to Northern Ireland, but after 6 months, if the UK regulator and the EU regulator didn't agree, then it could not stay in Northern Ireland and couldn't be administered in Northern Ireland. So what we would, a lottery for whatever medication you could or you couldn't get, compared to, I don't know, if you had a brother in Northern Ireland and a sister in London and they needed the same medicine for whatever, it would be a lottery as to whether they could or couldn't get it. And we did see a bit of that with the licensing and so on of COVID vaccines, where one was significantly behind the other in doing that. So is there an equivalent body of work in Northern Ireland? And do you know if the health department has a kind of equivalent body of work so that we could get that information and understand that issue better? It seems to me, it's a very, very significant issue. We were told this was sorted, done and dusted. Clearly, like everything else, the detail of it takes us somewhere else.
Yeah, so as you say, Diane, the issue of approvals of novel medicines is a big one, and how they work in terms of if one regulator moves more quickly to approve a medicine than the other, or indeed if they differ completely about whether a medicine should be approved. The Department of Health have said that they are working through the Commission proposals, the sort of more detail that came out in December, and they did say that they are looking for clarifications in terms of the longer term aspects, so beyond the sort of 6 month period that the EU has proposed, where either side can do the approvals. And they said that they are working with the Department of Health and Social Care in England to work out the detail of that. And I understand Minister Swan has written to Liz Truss on it as well. But I haven't heard any more in terms of a response on that. So I think, from that you can read that the Department of Health here is looking at that, but I haven't seen anything published about whether the proposals fully meet all the concerns that they have previously raised, especially around approvals.
Okay. Chair, could I maybe ask that is one of the actions from today, that we write to the Department of Health here, ask for their analysis of the EU's proposal on medicines and what actions they deem to be necessary to make sure that people in Northern Ireland have the same access to medicines as those people in the rest of the United Kingdom?
Absolutely no problem. I don't think anybody else will as well, so that we would have equivalence of access. Yeah. Absolutely. No problem.
Well, even if we just also have something around what their analysis is around the issues, sort of we try to tease that out into the open. What is the analysis of the issues with the EU proposal, and what's the proposal to fix those? Because, I've years of experience of reading EU proposals and legislation teaches me to look very, very closely at actually what is proposed, because you will always see the issues, and they're never that apparent at the start. So I just think that that's an important one, and one that we wouldn't want this committee not to have addressed before the end of the mandate.
No problem. Can I just ask for clarification there, Diane, as well? Is it analysis of existing medications as well as the potential for new medications or medicines as well?
Yeah, well, the EU has put forward a set of proposals in relation to bringing medicine from GB to Northern Ireland. And GB is our supplier, overwhelmingly our supplier of medicines into Northern Ireland. If those medicines don't have an agreed, some of them will already have an agreed regulatory process. So that's fine, and I'm presuming that, Shauna, you can keep me right, I'm presuming that they will be able to come because they've already that agreed process behind them. But the issue is then becomes quite acute for the development of new medicines, where a new drug for cancer or Parkinson's or heart disease or whatever it's for may well be licensed in the United Kingdom and not licensed in the EU, or may be licensed in the United Kingdom ahead of being licensed in the EU. And that way we would have no access to them. They could come here, I think, for 6 months, and then that would be it.
Okay,
We wouldn't have them.
that's great. We'll take
So it's
that as
really
a
about their analysis of the EU proposal, and particularly their analysis of the issue around new medications and the licensing of those new medications and how that would work. I don't think I've missed out anything from that, Sean. I think that's
No, I mean, I think that's fair enough, as you say.
that's the crux of
Now
it,
that
isn't it?
we've seen the text of the legislation, so we should be able to hopefully. I'm sure there's analysis underway on that.
So it would be really, really good to get that. I think the other thing that I would like to ask, I'm not quite sure, maybe Shauna can keep, I'm not quite sure who to ask this of, and that would be for an analysis of all the new legislation from the EU that now applies in Northern Ireland but does not apply in GB. So the EU hasn't stopped making legislation. It continues to make legislation on the single market and all sorts of things. So is there any analysis of the new legislation and the impact of that in Northern Ireland vis-a-vis GB, where it just doesn't exist?
I mean, I can come in on that in terms of just I guess from a procedural scrutiny point of view, the House of Commons European Scrutiny Committee and the House of Lords Subcommittee, they do a sift, a chair sift, and they are continuing to look at all those proposals. The government has committed to continue to produce UK government explanatory memoranda on any EU legislation that applies or could apply potentially under the protocol to Northern Ireland. So from a procedural point of view, it's still being received and recorded and looked at, but that's obviously with a Westminster eye, if you like. So the scrutiny is being done at Westminster between the Commons and the Lords of those. As you say, there's legislation on fertilisers, all sorts of things that are very clearly going to be different potentially for Northern Ireland than to GB. And that analysis has been done. And so when the government is doing the explanatory memoranda on those, they are still consulting Northern Ireland executive departments and seeking their input in terms of local impacts. So that process is still ongoing, really. A similar process what used to be pre-Brexit, that process is still as is. So there is scrutiny and sort of recording of those things taking place. Is
there anywhere I can get access to that information? Anywhere handy? I haven't time at the minute, obviously.
The House of Lords, for example, I know, and it may well be the Commons, that they produce a list. There's a list, but what I can do, Diana, is I can certainly send you a link to where they lodge the list, and you can have a quick scan through it if there's something of interest to you then. That's
brilliant. Thank you very much indeed. That's very helpful indeed. On a final note, Chair, and thank you for your forbearance in relation to this. In terms of sovereignty, so clearly we make our laws are made for Northern Ireland, that simply no one in either Belfast or London has any input into whatsoever. Has there been any analysis of the impact of that on the issue of sovereignty in the whole of the United Kingdom? No?
I'm not aware of it, other than it has come up in conversation at the European Scrutiny Committee in the House of Commons quite a lot about about how much of whether certain EU proposals do affect the autonomy of the UK in terms of its future policy making in some areas. But
I'm thinking of subsidy control.
Yeah.
So if you, for example, in Northern Ireland, for goods, we will have to follow EU state aid law. That may or may not be more generous than the new subsidy control regime that applies in the rest of the United Kingdom. I certainly think that there will be different attitudes to the bureaucracy around state aid law, where in the European Union you have to apply for approvals. And I think in GB you're probably going to assume it's okay until somebody tells you it isn't. I'm just wondering how that will work out, and whether if there's a linkage with a company in Northern Ireland, there will be clawback on that in GB.
Now, I'm far from an expert in terms of the proposals, but as you know, there was the discussion about what a genuine link to Northern Ireland means for a GB firm, what a genuine link actually would look like in terms of is it a regional office, or is it having a certain percentage of our customer base based in Northern Ireland, those kinds of arguments. And obviously, as you know, the government's position is that they would rather that Article 10 was replaced by the subsidy control regime that's already in the TCA, which is, in the UK's government's view, is much more straightforward and would be more suited to the UK as a whole. So, Article 10 would be replaced. But, I mean, I think that the government there's been obviously a few opinion pieces and articles about that, but because it's part of the ongoing negotiations, there hasn't been an awful lot of detail about, there was discussion, I know, at the House of Lords Subcommittee about the FDI and about the effect on Northern Ireland of being part of a separate subsidy control regime if you were a foreign direct investor in the UK, and what that would mean if you were investing in GB versus Northern Ireland, or potentially in both, that you would have to abide by two different subsidy regimes. So I don't think there's been much resolution reported on yet on that, and I think that probably that's because that it is part of the ongoing negotiations at the minute. But your question about sovereignty and about subsidy control, I mean, I haven't seen any analysis of that specifically.
So finally, in an answer, and I know you referred to it in your briefing there, in one of the answers, I think it was to my question in the Assembly the other week, the Agriculture Minister said that with the grace periods, officials were filling in about 2,500 forms per week, 10,000 per month. If the protocol were to be implemented in full, that would become 12,500 per week. So that's a very significant jump in the level of bureaucracy and form filling and so on. It's probably beyond us, to be honest, but there you go. Have any other departments done analysis along that line?
I don't know the answer to that question. To be honest, I think that certainly for, I'm thinking immediately just off the top of my head of the Department of Economy, who were discussing, for example, on common frameworks. They said until they see a lot of the detail, it's very difficult to try and assess implications, be it resource implications or cost implications of potential changes. So there may well have been, I mean, I'm sure there's something going on. Whether there's been anything published, I'm not sure. That's something I guess maybe other committees, the other statutory committees might be more able to answer that or share that with your committee. That's something you were looking for.
Okay, I just think maybe, Chair, that's a line of, and it's too late in the mandate now, but maybe it's an issue to raise, that if TEO is going to be responsible for looking at the broader aspect of European affairs and the implementation of the protocol and the impact that that's having in Northern Ireland, then having that information across government departments would be very useful.
It certainly
Sometimes you just get this stuff piecemeal because you've asked a question or
and to be
whatever,
honest, to be honest, Diane, you've hit on something there. We need more data. I've been saying this from the very beginning in relation to the implications, and that we need data, and we haven't got an awful lot of it yet. But what I do remark is there's more data coming in now in the last couple of months than we've had prior to that, and I suppose it is the settling of things and the understanding of the context of the protocol that we're getting the data, and I suppose as well with the information that we're getting regarding the common frameworks. But it is certainly something that if that the TEO, the department itself, but the committee going forward, as a legacy area, that we should have more information in all of the areas that you've raised. Can I bring Alex Easton into the spotlight, please?
Hi, Shauna. Thank you very much for your presentation. It was actually, I would actually dare to say it was fantastic. So well done. I was very impressed. I don't really have many questions as such. It's more some comments, and you might be able to answer me. I don't know. In terms at the beginning of your presentation, I think you mentioned a certain amount of goods that there had been a problem coming into Northern Ireland as a result of the protocol. And I may have picked it up wrong, but did you say there was over 200 goods that there were issues with? Was that right? No?
I'm just looking back through my notes here.
It was pretty much at the beginning. There's a certain amount of goods or something.
Sorry, I'm just looking through my notes. I think was it the comment that the Prime Minister maybe had made about I think that's probably what you're referring to. The Prime Minister did mention it was a PMQs in the House of Commons. He had said that whenever they negotiated the protocol, they didn't think that 200 businesses would stop supplying Northern Ireland. Oh. Yeah.
So 200 businesses have stopped supplying Northern Ireland?
Yeah.
Right. So my question is, would we be able to get a list of those businesses somehow? Is that possible?
I mean, the Prime Minister said that in PMQs. I can follow up and see. It wouldn't surprise me if that question has been asked in terms of other Westminster committees that maybe sought that information. So I can certainly see if I can secure that for you.
Yeah, that would be really interesting and fascinating to know what businesses have had problems and stopped using here. Just on your interpretation, I'm a bit concerned, although it seems to have improved negotiations at the moment, about negotiations maybe up to recent times. There seemed to be a problem with people's personalities rather than the actual issues. I would express a deep concern that we're never going to get anywhere if negotiations are based on people's personalities. So that would be a major concern if that's the way people were negotiating. But would you get a sense that the EU do actually recognise there are problems with the Northern Ireland Protocol, and that there is a willingness to try and find a solution to the protocol? Are they taking it seriously, or is it just all in your opinion?
Yeah, I mean, I think that the EU would very much say that they do take it seriously. They have, as you know, Maros Šefčovič has come over and met with businesses and civic society and has said that it's very much listening to the problems, and they would say that the non-papers that they issued in October were their best endeavours to try and deal with the issues around medicine, around the engagement side, and bringing businesses into the discussions. So they would say that demonstrates their willingness to find a solution, but ultimately they, at the same time, in all the public statements, will say that the protocol has been agreed and it's not up for renegotiation. So they would say that they're showing flexibility, but that's flexibility within the realms of the protocol as it stands. So I guess it's all a question of interpretation. I think the UK government has openly said they need more flexibility from the EU. The EU says that they think they've demonstrated a lot of flexibility. So I guess the gap in the middle is where we are with the negotiations at the minute about, both sides feel that they have shown flexibility, but they haven't managed to reach an agreement.
Okay, well, that's me. Thank you very much for your presentation. Thank you.
Thanks.
Okay, Shauna, I have no other raised hands, but it suffices for me to say thank you very much for your briefing to the committee today, and as always, and I don't suspect that, well, you're not on our forward work plan, but who knows, that we'll see you next week. So on behalf of the committee, thank you for the sterling work that you have done within the confines of this mandate. You've been very thorough and complete in all of your briefings here and all of the support that you give us with papers and that, and we're very, very grateful. Thank you.
Thank you very much, Chair. Thank you, members.
Okay, so that was that was a really good briefing, and we have some actions already banked from that. But in relation to the common frameworks, can I remind members that the committee wrote to those statutory committees of the Assembly which had responsibility for the scrutiny of the common frameworks, asking for their experience of the process, and can I refer members to pages 68 to 70 of the meeting pack for relevant papers. Members, 3 of the 5 committees responded, covering 21 of the 32 common frameworks. This paper, prepared by the clerk, provides a summary of those experiences. So can I seek members' agreement, if you're happy, for us to forward the summary of the paper to the Executive Office, the Lords Common Framework Scrutiny Committee, and copying relevant committees in the devolved legislators? Registers. Happy enough? Okay, that's grand. Right, moving on now to item 6, the Committee on the Administration of Justice Legal Research Report Oral Briefing. Can I refer members to pages 78 to 159 of the meeting pack for the relevant papers? And can I welcome to the meeting Ms Una Boyd, Immigration Project Coordinator, Committee on the Administration of Justice, and Mr Daniel Holder, Deputy Director, Committee on the Administration of Justice. And I'm delighted that Daniel is actually joining us in person here, so I'm not quite as lonely for this part of the meeting. And can I advise both that the session is being recorded by Hansard and that the video of the meeting will be available on the committee webpage. So you're both very welcome, Una and Daniel, and can I ask you to open up your briefing to the members?
Thank you, and thank you to the committee for the invitation. So the Committee on the Administration of Justice is an independent human rights organisation with cross-community membership in Northern Ireland and beyond. CAJ runs a strategic immigration project, which is led by my colleague Una Boyd, and the project's designed to promote a human rights compliant and welcoming immigration regime. As part of this work, we commissioned barrister Mark Bassett, BL, to produce the legal research report, Can Stormont Roll Back the Home Office Hostile Environment, that we're here today to discuss. This work was undertaken in the context of the suite of hostile environment policies introduced by the UK Home Office, particularly through the Immigration Acts of 2014 and 2016. The hostile environment openly aims to make the lives of persons in an irregular migration status unbearable through a range of measures whereby duties are placed on public services and private actors to police immigration status. The hostile environment impacts, though, on all migrants and persons who are wrongly perceived as migrants. Its policies, only some of which to date have been applied in NI, have already led to shocking practices of racial discrimination, most notoriously typified by the Windrush scandal. Yet since then, they're largely intact, and following Brexit, they apply to an even broader range of persons. It's notable, though, that the imposition of many Home Office hostile environment policies encroach in areas of general devolved competence, such as housing, employment, social security, driving and health. We've been concerned for some time regarding a culture of undue deference towards the Home Office, where it's assumed devolved departments are unable to act. In lay terms, there's an experience of a default position. We don't like this, it's nothing to do with us, it's up to the Home Office. But we don't believe that this is necessarily the case, as there are many areas where hostile environment policies encroach on transferred matters. Given the boundary between the accepted matter of immigration law and transferred matters is complex, we therefore commissioned this report. It provides an expert legal opinion that maps out the interface between devolved and non-devolved matters in respect of immigration and associated issues, and it examines where the Northern Ireland executive departments would have legislative competence to push back against the hostile environment and similar Home Office policies that have a detrimental impact on migrant rights. So the report first maps out the extent to which hostile environment policies have been applied in Northern Ireland, and there are some areas where, despite perceptions, they have not. Most notably in housing, where duties on landlords to police the immigration status of tenants have not yet been commenced by Home Office ministers here. We are aware, though, of perceptions that they have, and that has led already to racial profiling of tenants. But the report finds that if UK ministers did commence these powers, it would be within the powers of the Assembly to reverse the measures. So, some measures that have been commenced are things like policing immigration status through driving licences, which could be reversed by the Assembly, as could some hostile environment measures imposed on marriage registrars. In areas such as social security, the report finds that whilst there's not devolved power to remove the no recourse to public funds condition, as it's part of immigration status, it would be open to Stormont to create supplementary welfare payments, which would be part of the existing separate welfare mitigation scheme, albeit at a much more limited cost. The report also finds there's considerable scope to reduce restrictions on entitlements in healthcare services, including hostile environment restrictions on the definition of ordinary resident. And whilst it wouldn't be within the gift of the Assembly, the report finds to reverse the so-called NHS surcharge, where migrants are charged an additional fee of around £600 per adult, £400 per child, as part of the visas. The impacts of the surcharge could be mitigated here by reimbursing the fee to migrants. Employment rights are another complex area, but the devolved institutions would have some power to reverse hostile environment measures that remove the ability to enforce employment rights from irregular migrant workers who've been exploited in the workplace. And in areas where there are not currently powers vested in the devolved institutions, the Assembly could still take a strong and proactive stance in pushing for further transfers of powers or reform of legislation, as has happened in Scotland and Wales. Tension between central and regional governments worldwide on immigration matters is commonplace, with local authorities, regional governments often pushing back against draconian immigration controls in sanctuary cities and other places that have been imposed by central governments. There's been some pushback in Scotland and Wales, and here the Department of Communities pushed back recently against Home Office post-Brexit plans to remove rather than assist homeless migrants. Devolved authorities are no obligation to follow the Home Office lead in areas of their competence, and we've encountered significant opposition among local parties to the hostile environment. So CAJ is part of the Equality Coalition, network of over 100 equality groups and trade unions co-convened by ourselves in unison, which includes minority, ethnic and migrant groups, have called for a midterm review of the racial equality strategy. And whilst we're clear we want the current strategy implemented, and we would like to see it augmented and upgraded, and whether such a process or through other mechanisms, we would particularly like to see commitments under the auspices of the racial equality strategy to roll back elements of the hostile environment here where there's devolved power to do so, as our report has mapped out. We believe that this would reduce racial discrimination and make a real difference to people's lives, and we'd very much encourage the committee to consider making representations to the Executive Office to that end. Thank you.
Thank you very much, Daniel, for your briefing. You've indicated about pushback in the other devolved governments, particularly Scotland and Wales. Can you outline just some of the areas in which that pushback has, impacted on, and what we could do here potentially going forward?
I'd mentioned the issue of the Department of Communities here. I think that was also the case in relation to homeless migrants in Scotland and Wales. I think in Scotland and Wales also there's been a push for a change in approach by the Home Office, and particularly around the right to work of asylum seekers. Maybe I could ask my colleague Una to elaborate on that.
Thank you, Daniel. Yeah, in terms of Scotland, there's some specific examples that are worth noting. One was a strategy with regards to migrants subject to no recourse to public funds. And as part of that strategy, Scotland outlined actions that they could take within their devolved competency, but they also, it's more restricted because social welfare isn't devolved. And as part of that strategy, they did ask, for example, that Westminster remove Scottish welfare payments from the public funds list, and that would enable Scotland to provide those welfare payments to people subject to no recourse to public funds. So that was quite a creative example of working within their devolved competencies to address a really severe impact from the hostile environment. We also have seen recently, with regards to the Nationality and Borders Bill, both the Scottish Parliament and the Welsh Parliament refused legislative consent to the bill. They both made submissions, essentially opposing a lot of the proposals of the Nationality and Borders Bill, and even supporting potential amendments. I think both, for example, supported the idea that asylum seekers should be given the right to work. So those are just some examples, and I think particularly in Scotland, it's created this culture where they don't just say the Home Office says, so we have to do it. They do examine it and push back where they can.
Yeah, I mean, they're very loud in doing it as well. Earlier, I mentioned a report that we've received from the Northern Ireland Affairs Committee on the experience of minority, ethnic and migrant people here in Northern Ireland. And some of the statistics in that report were deeply troubling and obviously must be addressed. And you refer to changes that you'd like to see in the racial equality strategy. Can you maybe specify about what you'd like to see changed?
Yeah, in terms of the racial equality strategy, I mean, it's a strategy with already some fairly solid recommendations in, but it is a bit dated now. It predates Brexit. It predates the pandemic, which obviously has had specific impacts. And it predates the Black Lives Matter movement and the various issues that have surged from that. One of the issues the racial equality strategy could do is it could map out a blueprint for rolling back hostile environment measures that are within devolved competence. I mean, ultimately, we would like to see that taken forward through legislation, through an executive bill. But given as the hostile environment has led to so much racial discrimination, and that is the main impact of it, it doesn't actually, there's no evidence that it does what it was expressly put there for in terms of reducing irregular migration. There's ample evidence that it's succeeded in making the lives of many people deeply, deeply miserable, but also specifically that it's led to huge amounts of racial discrimination. And there are risks that will increase in the post-Brexit context where it's applied to many more people. Therefore, we think this is a key issue that the racial equality strategy could be grappling with, both at the level of what legislative changes can be made here within devolved competence, but also in terms of what representations can be made to the UK Home Office, particularly on some of the issues that are emerging about the hardening of the land border for particular groups of citizens who, to date, have either faced a hard border through being visa nationals and being subject to immigration control, or will do through some of the Home Office's proposals for things like electronic travel authorisation that hardens the border for groups of people that up until now have been able to freely cross it. I think if the racial equality strategy doesn't tackle those issues, then it leaves a huge gap in protections and a huge gap in dealing with many of the issues that hit the lived experience of migrant and minority ethnic communities within this jurisdiction.
Obviously, the Ukrainian refugee crisis is impacting the whole of Europe. And we, as a society, want to support refugees coming out of war-torn Ukraine. But everything that we're talking about today in relation to hostile environments and that, this crisis could impact on that environment and make it even more hostile if we don't have the right plans in place. Have you any observations or any thoughts in and around that? I know it's a little bit out of the report that you have presented to us, but it's complex in terms of, but it sits there in terms of immigration and minority groupings as well.
It absolutely does, and I mean, I suppose the first point is the hostile environment will apply to Ukrainians on arrival here, and I think the context for Ukrainian refugees, obviously there's been a significant humanitarian response for the Irish government in removing visa requirements, meaning that there's the opportunity for Ukrainians to arrive into the Republic, but people may have friends and family within the north they wish to stay with and visit, and that's where it gets more complicated. My colleague Una may wish to say more on that.
Yeah, certainly. I don't think the Ukrainian crisis is sort of separate from what we're talking about today at all. I think it's highly relevant because what we're looking at there is, as Daniel said, a group of people who will be subject to hostile environment policies. And when we look at the Nationality and Borders Bill, a lot of the rhetoric around that bill is that, you know, the UK is going to create safe and legal routes for refugees. They're going to penalise people who don't come through sort of these specific routes. And the sort of response to the crisis in Ukraine has been essentially has shown that that's not feasible, that safe and legal routes aren't readily available, you know, don't work in a situation like this. And the end result is, at the moment, you know, some of the visa schemes available for Ukrainians, you know, aren't even in place for the UK. But, you know, people need to react to a situation. They will try to reach particularly friends and family and a place of safety. And for many of them, because the UK hasn't provided a sufficient response or a particularly accessible, safe and legal route, they risk arriving in the UK in a way that exposes them to the hostile environment. For example, you may have Ukrainians already living here who their visa might expire and obviously they can't return home. But once that visa expires, they could be subject to all kinds of hostile environment measures. You could have Ukrainians who use a visitor visa because they've no other option and attempt to enter the UK that way. And once that visitor visa expires, they too will be subject to all kinds of hostile environment measures. So yeah, it is just a really good example of how it can be applied to people, you know, even when they're coming as clearly as in response to a crisis as a refugee.
And just another quick question in relation to the Nationality and Borders Bill. I mean, I'm really conscious of our particular set of circumstances here in Northern Ireland and the common travel area. Do you believe that it would be in the interests of everybody on these islands to have the common travel area, you know, legislated for within the context of the Republic of Ireland and UK, because it's very loose at the moment, and we've seen that as a result of COVID and COVID restrictions and one thing and another. But certainly when we're talking about hostile environments as well, it does, you know, it's very much open to interpretation and you know, the fear in relation to the ETA and the impact on the common travel area is very, very real, and it's approaching us very quickly.
Yeah, absolutely. We think, I mean, I know the Human Rights Commissions have done a bit of work on this as well and mapped out really that the common travel area at the moment is written in sand, and it really needs both an underpinning and enforceable treaty and also domestic legislation. But there is another issue that's particularly emerged over recent years, which is the direction of travel from both governments to actually restrict elements of the common travel area to particular groups of citizens. So the concept of reciprocal rights of the common travel area, which didn't exist before Brexit, I mean, equality for British and Irish citizens was largely retained through EU law, has been developed by the two governments to plug the gap left by the removal of EU free movement law for British and Irish citizens. But essentially what it does is restricts some things that were previously available to a much broader group of people, to British and Irish citizens. When you look at what the common travel area is in terms of a free movement area as well, we think a key thing is, yes, that it needs written into treaty and legislation, but it also needs to be extended as to who it applies to. Yeah. I mean, if you look at one of the, and I know there are migrant groups protesting on the border this weekend at the fact that the common travel area does not apply to everyone, and there is an existing hard border for particular groups of citizens. And through the Nationality and Borders Bill, there is an attempt from government, and I know thankfully it's been defeated in the House of Lords so far, to bring in the travel waiver requirement, which hardens the borders for groups, for particular groups of citizens who live in border counties. So EU citizens, non-Irish EU citizens who live in a number of the border counties, who freely live cross-border lives up until now, could be facing up to 4 years in prison for not applying for a travel waiver before simply crossing from, say, Lifford to Strabane on a local journey, or for any other reason, or even transiting through Northern Ireland. And that really is essentially hardening the border, but it reflects an existing situation and problem for people who are visa nationals. So people who are from countries that require visas for either state get trapped in one jurisdiction. So you will have people living, as you will know, in the city of Derry, who cannot visit Donegal, or sometimes what happens is half the family can and the rest of the family can't, because they can't cross the border without going through the complex and expensive process of visa acquisition for what are short journeys. It would be within the gift of both governments to quite easily alter that, and to take a position whereby someone who has lawful residence in, for example, the city of Derry or in Tyrone or wherever else, or anywhere in Northern Ireland, the Irish government could allow those persons to travel into the Republic as a visitor, just without needing any prior permission, and vice versa. The UK could do that as well, so that someone who is resident in Donegal isn't trapped there, unable to visit to visit or to go to shops or whatever in the nearest city to them. So we think there's quite a lot that needs done about the common travel area. Yes, enshrining it properly and giving it a proper legal basis is one thing, but certainly that these efforts to restrict it need to stop in our view, but also the provisions in it need to be expanded so that it's really a common travel area for all and not just for some in relation to freedom of movement on this island.
Thank you, Daniel, and I couldn't agree more. My colleague that heads up the Northwest Migrant Forum, Councillor Lillian Sinor-Barr, is working on this issue, in particular, as you say, a border area where families cross borders, and yet some people can't because of their status, and the CTA absolutely needs to be enshrined in legislation, and we need to have proper definitions and provisions made, an extension of those provisions as well, to people that actually live and reside on both sides of the border and between the islands as well. So I'm going to ask a question now, but I'm going to come back to you to get the answer before the end of this, because the question I'm going to say is, if you would like us to raise 3 things and ask the department on your behalf, what are the 3 priorities in relation to the work that you're doing? But I'm not going to put you on the spot now, because I want other maybe members to come in and have a conversation and ask you some questions. So Emma Sharon, can I bring you into the spotlight?
Thank you, Chair, and thank you very much, Daniel and Una, for the presentation and the answers that you've already given, as always. The information that you have on this issue and on the rights deficits that people across the North are living with is astounding. And I had taken part in an event on Monday afternoon that was hosted by the Equality and Human Rights Commissions around rights after Brexit. And there were some really powerful testimonies at that event as well from people living on both sides of the border who had experience of racial profiling, barriers to accessing healthcare, being able to work, the issue that you've referred to there around this ETA requirement. And I know that has potentially it has been maybe paused, or there's an attempt to roll back on that through the House of Lords, but it still has to go back to the House of Commons and could be implemented as initially feared. So the thing I suppose to ask, the questions that I have for you, the thing that we hear all the time when we meet with groups is that people have difficulty accessing their socioeconomic rights. And obviously I had chaired the ad hoc committee on a Bill of Rights, and the overwhelming feedback that we received through all of the consultation and engagement that we did during that was that the majority of the people in the North want to see greater socioeconomic rights and greater access to socioeconomic rights. And at the minute, the British government are obviously talking about Human Rights Act and the changes that they're making there. And myself and Chris Hazard had met with Dominic Raab last week, where he was talking and focused heavily on rights of freedom of speech and rights that, whilst are important, are not what our constituents are telling us that they are scared about losing or feel that they have already lost. So I wondered, around things like healthcare, like what changes can we make to hostile environment in the North here? Like, for example, the Department of Health on the change to the age assessment. Is there scope there for us to sort of roll back or create some mitigations to this policy? And then obviously, as part of the report, you've dedicated a section on the right to work. I wonder what your thoughts would be around enshrining that as a right and ensuring that people on both sides of the border that come here from other countries have that right, with the issues that you've referred to there around travelling north and south.
Thank you for those questions. Well, let's start with the Bill of Rights. A Bill of Rights, had it been legislated for on the basis of what the Human Rights Commission advised back in 2008, would have spared us from considerable elements of the hostile environment. Their implementation simply would not have been lawful here. So some of the provisions in the Bill of Rights around the right to an adequate standard of living, i.e. preventing destitution, etc., the arbitrary nature of the hostile environment wouldn't have been lawful for that. We'd hope that the right to work, which could be limited in at some extent under a Bill of Rights, but some of the issues around employment exploitation hopefully would have been safeguarded by a Bill of Rights. In terms of the issue of health, what we've mapped out is that most of the issues around the restricted categories for who isn't entitled to health services are a devolved matter and could be amended. That seems relatively uncontroversial, so additional groups could have free access to services. The Home Office also legislated to change the definition in our health legislation of ordinarily resident to make it a lot tighter. That's something that could be reversed by the devolved institutions. What we also found was, whilst this NHS surcharge, kind of a double tax for migrants in terms of use of the NHS when people are already paying taxes, etc., because it's part of a visa system, it can't be reversed by installment, but it could of course be reimbursed. Some sort of scheme to compensate people for what the Home Office has done could be put into place. In terms of the right to work, whilst we found that as a matter of immigration status, that is a Home Office matter, unfortunately it wouldn't be within the gift of Stormont at present. There's nothing to stop Stormont for asking for the additional power to be transferred to grant a right to work. However, there are a number of areas where the hostile environment has essentially removed employment rights from migrants who find themselves in an irregular status. Therefore, you can't claim, when you're exploited, you can't claim. So, and that actually provides an incentment for exploitation. So you take the example of, I don't know, someone who's been exploited in the workplace, they're pushed into an irregular status, and the employer who's exploiting them knows that they then can't take claims for, say, to back pay for the minimum wage or for maternity pay, and hence those rights are then abused. These are things that the hostile environment facilitates because it removes people's rights to claim their employment rights when they're in a regular status. That is something that could be reversed by Stormont, and there are other elements too. I don't know if it's okay if my colleague Una may wish to add.
Yeah, thank you.
Thank you, and thanks for the questions, Emma. I'm just going to touch particularly on what you mentioned about the Nationality and Borders Bill. There are a huge amount of the bill, does deal with immigration in a way that would be an accepted matter, but there are elements of it, and Mark touches on this in his report, that do encroach, on devolved competencies. And one that you raised is a really good example of age assessments. So, currently the trusts here have developed their own method of conducting age assessments, and it's a really controversial area of the asylum process, particularly. And they worked with experts in the Children's Law Centre, for example, to make sure that process was, human rights compliant and protected children involved. And all of that work, which has been really positive and is something that we can kind of be proud of here, would be completely overturned by the changes to the age assessment suggested in the Nationality and Borders Bill. And that's very clearly, it's not only a regression, it's a regression in a devolved area, and something that doesn't have to just be accepted as it's immigration, and therefore we can't do anything about it. And also just on the right to work, as Daniel said, Mark's report, has found that it may be limited in terms of what Stormont can do in terms of creating a different employment regime for migrants living in Northern Ireland. But what is important to remember is that there's still a lot can be done in terms of pushing for change in Westminster, or potentially even pushing for a change and a transfer of a power. And there's a UK-wide campaign called Lift the Ban, which you might already know about, which is just focused on the right to work for asylum seekers. And it has shown, it's over 200 organisations are part of it. It has shown that it would have huge economic benefits to the UK to let asylum seekers work. It has shown, it takes strains off public services. It improves mental health. It improves integration. Over 70% of the population support it. And when you look at campaigns like that, we've seen, for example, Scotland and Wales both publicly support that they would like asylum seekers to be permitted to work. And that is something, that could be done, even though the actual devolved powers are a bit restricted. Thank you.
Thanks. I suppose, apologies, I've got COVID, so that's why I sound like this. But I suppose because in Mark's report, when he refers to the right to work and the fact that it's maybe not literally listed or not literally protected by the ECHR in terms of the North, but that the right to the court and law has actually protected people's right to work and access to the European Court of Human Rights, and then obviously that there are some provisions for I think it might have been temporary migrant workers that the reference was, and we know that the British government are repealing the Human Rights Act, and there's a fear there that that's going to mean that we're going to lose or access to some rights under the ECHR, obviously as part of the fact that the Good Friday Agreement sort of rubber stamped that. And it's just the whole thing, and even the situation with Ukrainian refugees now, and the fact that, you know, certain states in Europe just opened their borders straight away, no questions asked, and the British government wouldn't do that. And it's a process that's been put in place, and the attitude towards asylum seekers, refugees, migrant workers, anyone from any other country is consistently hostile. It just, I suppose, it creates that fear. So anything that we could be doing in the north to create a different situation would obviously be welcome. And I think that's something that we need to be looking at in a new mandate as a matter of urgency. But thank you for that.
Thank you very much, Emma, and I hope you're feeling okay and you improve. Good on you. Anyway, you're here at committee. Doing due diligence as well. Thank you. So I'm going to come back. I have no other hands raised at the minute for questions, but I'm going to come back to that question that I put to you about the 3 big asks that you would like us to ask the department to do. So I know 3 is very limiting in a way to make them a big 3, but and there is so much work to be done, and we've, you know, touched on a few of the key issues there, and some of the evolving issues that are taking place as we speak in the global context of rights and that. So. Daniel, can I maybe start with you to see what you think are the major issues that we, as a devolved administration, need to be actually laser focused on and driving change that we, as a devolved administration, which hopefully will be back again after the elections, that we can actually prioritise going forward?
Thank you. I've managed to multitask and do my homework here, so I do have 3. The first one would be that we would like to see an upgraded and augmented racial equality strategy. We'd like to see the Executive Office engage with migrant communities, perhaps get the sort of model of an expert advisory panel to inform that strategy. And we would hope, for all the reasons I've previously mentioned, that the strategy could be augmented to include many of these issues, which really, really are key, and to just get a bit of a shift that these issues, just because they engage sometimes the powers of the Home Office, are not out of bounds, because they engage devolved competence a lot, but also there are areas whereby the devolved administration could make asks of both governments. That brings me to my second and third things. Really, the second issue is what we'd really like to see from the Executive Office would be essentially an action plan on the hostile environment, mapping out how the devolved institutions could take forward a rollback of many of the hostile environment measures that are within devolved competence and could push the UK Home Office for changes on. And then the third thing really relates to this issue of the common travel area for all, and making representations to both governments to allow free movement and local journeys across the land border for all people who are resident here, rather than there being an invisible hard border for some, but also to deal with the issues of selective passport controls that are occurring both by the guards on the southern side of the border and also on journeys between Northern Ireland and Great Britain at ports by Home Office officers. These are the controls that there's no, in the UK context, there's no, the legislation says there are no passport controls within the common travel area, yet there has been a pattern and practice for many years of immigration officers stopping passengers and engaging in checks for which there's no clear legislative basis, on the basis of sometimes what's quite blatant racial discrimination. Yeah. Racial profiling, either singling out the only black person in the queue, which we've numerous examples of, or in some way asking or kind of making an attempt to ask all passengers for ID, but only really expecting some to produce it. We think these controls, real informal sort of immigration controls that end up being essentially, ends up putting I suppose you could call it a racist border in the Irish Sea, about which there should be a huge outcry, where people are actually singled out on the basis of their skin colour. And we find the same pattern with the checks conducted on cross-border buses by Angara Chicana, where persons will be singled out quite often on the basis of quite blatant racial discrimination. And in fact, Irish law in itself is discriminatory, in that it requires only certain persons to carry and produce passports and others not to, crossing the land border. And I mean, the obvious question, well, how do you tell the difference? And we know exactly what happens in relation to those checks. So we think there's plenty that the executive could be making representations on to the two governments on those particular issues.
Thank you very much. You did well there to get absolutely everything in those three headways. And thank you to yourself.
That's a question from Diane.
Oh, sorry, I've got a hand up here. Can I bring Diane Dodds into the spotlight, please?
Sorry, Chair. I thought I had put my hand up, and then obviously I hadn't until too late. So apologies. Won't keep anybody very long. Just a couple of questions that I want to ask. Daniel and Una, do you accept that as a sovereign nation, the UK should have its own control of its own borders and security?
Sorry, is that the question? Yes. In relation to where human rights law sits, states are allowed to regulate migration. We just see that the hostile environment is not a proportionate way of doing this. It's not an effective way of doing it, and it leads to widespread racial discrimination. So yes, of course, human rights law allows states to regulate migration. What we're opposing here is essentially racist immigration controls that have that kind of impact.
Okay, just establishing that. The title of your report, The Hostile Environment, is that pejorative?
It is an incredibly pejorative term, yes. Hostile environment's a pejorative term. It's normally used in things like war zones. It is, of course, Theresa May's own title for this suite of policies. It's not our word. This was the language that was used when the measures were introduced. It was expressly said that the aim was to create a hostile environment for irregular migrants, and then although that's encompassed a broad range of interventions, most of the provisions that actually give that legislative impact were then legislated for within the 2014 and 2016 Acts. And the hostile environment, despite everything that happened with the Windrush scandal, is very much still there and still with us.
Well, I found significant areas of disagreement, and you'll not be utterly surprised by that. But I absolutely agree with you that our immigration policy should not be racist, and should treat all people equally, irrespective of where they come from and what their motivation is. And in the sense, the process should be the process, irrespective of who people are. I'm interested in just a couple of things that interest me. You say that Northern Ireland should potentially push to change some of the issues around things like charges and so on. Now, I accept that people coming to our shores are some of the most vulnerable people in the world, and a compassionate society will reach out to those people. And that is my view on this issue, a very firm view. But just have you done any work on this and what it would cost to the Northern Ireland block grant? Is there any estimate?
In terms of the short answer to that is no, we haven't done the precise sums on it. But in terms of the issues, obviously the health surcharge is going to be quite a small amount, if you think. And indeed, in relation to the issues on social security, what we found is it wouldn't be within the gift of the executive to remove the no recourse to public funds criteria, but it could introduce supplementary funds. I suppose when, as you will know, when the Northern Ireland Assembly has sort of digressed from Westminster social security policy, there has always been an issue around costs. With this particular issue, we'd see that as quite minimal. because what you're talking about is a tiny, tiny range of people. It's a drop in the ocean. I mean, it's less than maybe 1 or 2% of the population would have that type of no recourse to public funds condition attached to them, probably less than 1%. And very few of them would actually end up, most people would be in work all the time, very few of them would end up actually needing support. So this really is a measure that would meet the type of things that you've said about being a compassionate society, because it would have minimal cost. It only really kicks in when people find themselves in the unplanned situations in life where work is lost or where something happens and they end up in a situation that requires social protection.
Okay. Have you considered, because this is something that comes up and you hear a lot from civil servants, that if we change, for example, social security policy here, that might have a cost ramification in that there could be, for example, a test case in other parts of the United Kingdom which said, well, you do it, and then because we've set the precedent, we pay for it. Just trying to tease out the issue.
Yeah, I'm not familiar with that particular issue. I mean, my basic understanding would be that if Social Security is uniquely devolved here, then there can be a different policy. I'm not aware of issues around whether that policy would therefore have to be replicated in other parts of the UK.
It might have to be replicated, but if it was, my understanding is it would have to be paid for. But anyway, just an interesting point. I'm just making a point. Why do you assume that legislation for the common travel area would be a good thing?
Well, this has been dealt with in quite some detail by the Human Rights Commission's reports, and what they find is that many of what are set out, what are now called reciprocal rights that are set out in the Memorandum of Understanding, have a very fragile legislative basis, so therefore they could be changed at the whim of any new government at any point, whereas if you're talking about enshrining a common travel area where there's freedom of movement and equality of treatment for those captured by it, which we think should be much broader, it's going to need a much more solid legislative basis rather than something that is quite vague. That's the usual sort of legalistic answer. At a human level, it just ends up being a nightmare for people when it's not actually clear what their entitlements are or how can they avail of them, or when people interface with the bureaucracy and find out that rights that they and entitlements that they thought they had, and this is moving away from the migrant issue, it's much broader, they don't actually have or can't obtain, therefore actually setting out a much more solid legislative basis for the common travel area is what the Human Rights Commissions have recommended, and something that we'd very much support for those reasons.
So is that only on the basis of rights? I mean, I'm interested in thinking, because I'm thinking of, for example, the mutual recognition of qualifications. So within the common travel area, if you train in Dublin as a doctor, you can practice in London. Same the other way round. But since we left the European Union, there has been some difficulty, and instead of a blanket recognition of those qualifications, my understanding, I could be wrong in this, but my understanding is that it is now on a case-by-case basis. So really, this would require a change in the law, both in the Republic and in the United Kingdom, wouldn't it?
It may require a treaty between the two to underpin it as well. Actually, just the prior event I was at before coming here was a cross-border event with the British Association of Social Workers, where many of these issues actually came up about mutual recognition of qualifications with the dropping of the EU law framework. At the moment, I think, I'm not totally sure, but I think it is referenced in the Memorandum of Understanding on the Common Travel Area, the 2019 one. Yes. But again, if there's no legislative basis to back that up, then the type of problems that you suggest are likely to occur, and people aren't going to be able to access recognition in the same way. The only other possible vehicle here is through Article 2 of the Northern Ireland Protocol, which is not the bit about trade, but is the UK commitment to non-diminution and certain rights under the Good Friday Agreement, which includes the right to equality of opportunity and social economic activity as a result of the UK's exit from the European Union. So if the situation has diminished since the end of the Brexit transition period, then it would appear that particular provision is engaged, and there'd certainly be an onus on the UK to take remedial action to that end to ensure a similar level of qualification recognition that occurred prior to the transition continues to occur.
Okay, one last comment, and thank you for your presentation and just for the information to augment where we are. I absolutely agree with you that an upgraded and augmented racial equality strategy would be very good for Northern Ireland. I think that we don't do enough, and I think that the report this week from Westminster says that it's too ad hoc what we're doing in relation to equality and particularly racial equality, and I would like to see that upgraded and more embedded across services and government. I think on the Article 2 of the protocol and the diminution of rights, people like me from the Unionist community understood that our rights under the Belfast Agreement was that on those issues that were cross-cutting and contentious, that they would be given rights and safeguarding of those rights using the cross-community mechanism of voting. Have you done any studies into how this has impacted the Unionist community since that cross-community mechanism has been taken away?
I'm not sure we'd agree that the cross-community mechanism has been taken away. We're getting into a whole different and complex area here, of course, but what usually happens is the cross-community consent motion in the Assembly favours the status quo. And the status quo is the protocol. Now,
well, I mean, of course, I would argue that the status quo wasn't the protocol. The status quo was the 1998 Belfast Agreement.
I think we're going to end up rehearsing a number of other arguments here, but the status quo was also being in the EU, and there was no cross-community consent for that. One thing I would say, and I mean, we have engaged, just on the engagement issue, we engage with lots of people on these types of issues, and there are obviously, as you'd know, varied views on it, but we have tried to engage on the issue of sort of reassurance. I know one of the worries is that if Northern Ireland diverges from the rest of the UK through trade and things like that, does that diminish Northern Ireland's position in the UK? Our understanding of that, even from looking at this particular piece of work, is that simply isn't the case. Because if you look at the administration that which we did for this bit of work, the administration that ran Northern Ireland from 1921 to 1972, it diverged in practically every way possible, including to the extent which you may have come across as Economy Minister during that era of actually having its own separate work permit system for persons who wish to travel from either the rest of the UK or from the Republic of Ireland to work here. So that just, in some senses, the issue of divergence, we don't think that there should be such a level of concern around that, because that's always been the case, including in issues around this. If we could get back to a situation, in fact, where the issue of work permits and devolved power, to bring it back to this report, was transferred to the devolved institutions, that would give us even more scope in terms of removing some of the elements of the hostile environment and having a much more human rights compliant immigration regime here.
Thank you. Really nice to engage with you, and thank you. Thank you.
Okay, Daniel and Una, again, thank you very, very much for your briefing and your presentation this afternoon. You've given us 3 takeaways there, and I'll discuss them with the committee once you leave. Thank you very, very much. Thanks. Okay, thank you, Daniel. Right. So, members, can I seek your agreement to write to the Department detailing the Committee on the Administration of Justice the three main asks? And if I just go over them again very quickly without the detail, but one, the upgrade of the racial equality strategy and the augmented strategy to include the key issues as we discussed. And the second was an action plan in order how we, as a devolved administration, can mitigate against the excesses in the hostile environment. And then thirdly, looking at the common travel area and the whole freedom of movement and embedding it and enshrining it in legislation, but also expanding the terms of reference and those that it affects. And again, looking particularly about stopping selective passport controls within the island and between the islands. Are members happy for us to write to the department and put those three areas to them, three issues? Yeah? Okay.
Yes, Chair, absolutely.
Okay, thank you very much. Okay, so I'm moving on to item number 7 in our agenda, and this is the request for accelerated passage, the Emergency Exceptional Circumstances Bill that was sent to us last night, this morning, by Mark Hitch-Durkin, my colleague. So can I welcome Mark to our meeting today? And I know this is a very much an evolving situation, and a lot of work has been done even this morning, because I had difficulty getting in contact with Mark because he was embedded in the Bill's office, and obviously the circumstances for which he is asking for this permission from the committee is because of the unique circumstances that we currently find ourselves in relation to spend. But can I refer members to the request from the bill sponsor that was sent out by the clerk today, and really just to inform members, because we haven't had an opportunity to really discuss this, that this session is for the bill sponsor, Mark, to explain to members what the bill does and the reasons that he is requesting accelerated passage and the circumstances in and around that. So can I invite you, Mark, just to address the committee this afternoon? Thanks.
Thank you, Chair. Good afternoon, and good afternoon to members. Thank you very much for having me. I'm sorry about the ridiculously short notice. We are working in a very narrow timeline, as you've outlined. I was relieved there when you says I was embedded in work with the Bills office. I thought you were just going to say I was in bed, so I was panicking there briefly. But pleased to come along today and seek approval from the Executive Office Committee for accelerated passage for the Emergency Exceptional Circumstances, Energy Prices and Other Contingencies Bill. That's the working title of this bill. Following some of my engagement with Bill's office today, I think that it's safe enough to say that's not the title that we're going to end up with. However, the effect and intent of the bill remain unchanged by ongoing drafting changes. This afternoon now I can outline, I suppose, the broad intent of the bill, the rationale behind it. But as you've outlined, Chair, today is to ask for accelerated passage rather than a clause-by-clause explanation of the bill, or getting into the technicalities of it. I mean, as you and other committee members will be aware, people and families across Northern Ireland are currently experiencing an unprecedented crisis due to the massive and ongoing increases in fuel and energy prices. That's making the cost of living unbearable, completely unaffordable for many in our communities. That's really what spurred us on to do this. Your committee knows better than any, I suppose, the difficulty that we've encountered over the past number of weeks, and that we encountered for 3 years, a couple of years ago as well, where hands are tied due to an inability to actually spend money that is here in a way that will help people. This bill is drafted and designed as an amendment to the Financial Assistance Act, which in ordinary circumstances empowers the First and Deputy First Ministers acting jointly to designate executive departments to take forward schemes for listed matters. However, in the absence, like we have now, of a First and Deputy First Minister, and in the circumstances that the Assembly currently finds itself in, the Financial Assistance Act can't be deployed to provide financial relief to people, households and families in Northern Ireland faced with those exceptional costs that we've referred to. Now, this bill, as it is an enabling piece of legislation, will enable more ministers to do more on more issues, not just on the energy end of things. I would envisage potentially UK government response to the Ukraine situation and new money being allocated here through a Barnett consequential for some scheme to help refugees. Should that happen again in the absence of First and Deputy First Ministers, we'll be getting money over here for a purpose that we won't be able to design, deliver a scheme for that purpose or that serves that purpose. I don't think any of us want to be there. In terms of the need for accelerated passage, I don't think that could be any more obvious given the extremely narrow time that we have left. That this is like not accelerated passage, it's almost turbo boosted passage that we're seeking for this. There are procedural barriers. I've outlined some of the work ongoing, I won't say difficulties, in trying to ensure that the drafting is correct, that the bill is fully competent, but I don't think we can afford there to be any political blockages to this attempt. It is an attempt, it is ambitious, but it's not impossible, and I think it's important that all parties sort of get behind the attempt. I'm not precious about ownership, nor do I claim or profess the bill to be perfect. It's more perfect now than the copy that I furnished you with. I have to say, though, it's closer to perfect now, but it's still fallen short. But we're not precious about that, and I think it'll certainly benefit from having input from other parties. At this stage, I have engaged with all the executive parties. I've also furnished smaller parties and independents with details of what we're trying to do. I've had some feedback from some parties, some which has helped actually inform the further work that we have done, but we still do have a way to go, and this is a hurdle. Your committee and the granting of accelerated passage or the approval of it is one that we have to jump, and I don't think you would want this attempt to fall flat on its face at this stage.
Okay, thank you very much, Mark, for that overview. And obviously, it is a unique set of circumstances that we currently find ourselves in that has led to seeking this accelerated passage. And obviously, I mean, to say that the runway is short for landing this would not be an exaggeration at all. But I think, it's incumbent upon all elected representatives to find solutions to the circumstances, the cards that we've been dealt with at the moment. If circumstances were normal and we had First Minister and Deputy First Minister in place, obviously this accelerated bill and passage for a bill wouldn't be necessary, but it is, and it just so happens that we're coming the week before the end of the mandate. But you mentioned in your briefing there, Mark, that you have engaged with a number of parties and seeking cross-community support, because the only way this is going to work is if everybody gets behind it, if we all start pushing in the one direction. And in your engagement, can you give us an idea of the level of support that you've received?
Yeah, well, as I outlined, Chair, I had met with representatives of all the executive parties to brief them on the legislation, its contents and those procedural barriers that I had referred to. Some of them spotted new procedural or potential procedural barriers which is in turn are the anticipated ones that have helped us maybe circumnavigate those, which is good. But people have been supportive in principle, without a doubt, and believe that it's definitely worth a shout.
And what would the consequences be if this bill doesn't receive accelerated package?
Well, it just won't go anywhere, basically, but without accelerated passage, the bill will fall and families across the north will be forced to endure the full force of this emergency, as I've referred to it in the bill. We might not refer to that in the final bill, but they'll have to endure it without the help that we can provide, but currently aren't able to provide. I don't think any public representative should really stand for that. Politics is the art of the possible. This is about finding a way to cut that Gordian knot that has tied the hands of ministers and prevented them from being able to design and deliver schemes or extend existing schemes to help people. It'll mean, well, we've wasted a bit of time and effort. It won't be the end of the bill. The end of the mandate won't necessarily mean the end of the bill. However, this is something that could be applicable post-election too, if we're unable to form an executive. Of course, that's the optimum solution here. The most effective way to deal with the emergency that we're facing is the nomination of a First and Deputy First Minister, for them to give direction under the Financial Assistance Act. But it's looking less and less likely that that's going to happen before the mandate ends either.
And Mark, you kind of indicated, like, you know, the nature of a hokey-cokey type government where a party may lift the ball and go off, but we're all then left to try and kind of work with difficult circumstances. So, okay, you might leave the executive, but can you leave the ball behind so that others can actually try and deliver some support for those most need? And this particular ball at the minute is that £300 million that we could spend to supporting families most in need now under these circumstances. So, you know, I'm going to open it up to other members for them to ask questions. And the first I have on the list is Pat Sheehan. Pat, in the spotlight. Thanks.
Thanks, Sinead. Thanks, Mark, for coming in. And you're absolutely right. If this is going to get through, there's going to have to be all parties putting their shoulders to the wheel. Just first of all, and I'm asking this out of curiosity more than anything else, why this committee? Why have you brought it to this committee? I'm not sure it's a natural fit here. Go ahead.
Yeah, no. Well, I suppose it's because we're looking at that Financial Assistance Act. You'd think, given the name of that it would be the Finance Committee. I'd be going to. I have written to the clerk and chair of Finance Committee, who'd come back to me. I believe it was discussed at that committee today. However, they were of the view, as were others, that it would be the Executive Office Committee, because that Financial Assistance Act gives the power to the First and Deputy First Minister. I also went to my own committee, or the committee that I sit on today, Communities, who aren't the relevant committee, but I believe are a relevant committee, given that it would be envisaged or assumed that if we're talking about schemes to help people, that we might be building on to one of those schemes already designed and in the process of being delivered by your own colleague, Minister Hargey.
Okay, no, that's fair enough. I just wasn't sure why I was coming into this committee. So tell me now, what advice are the Bills Office giving you?
It's not impossible. It's not impossible. In terms of competency, it's with now legal clerks. They're going to come back to the Speaker's office on that. I was with the Bills Office today just around particular drafting issues. I hope you appreciate, well, as an MLA, you know how long it takes to get legislation together, and then it's still far from perfect. So whenever there's the two of us been working hard on this, including our man in Washington, well, he's in Washington this week, bits have been coming in from left, right and centre, but we're pretty sure now the version we have is comprehensive, cogent and competent. There's been engagement between the whips as well, I believe, and will be further engagement, so that if the Speaker is able to give us go ahead based on the legal advice that his office receives, then I think parties can work then on the standing orders piece and what can be done to get this on the floor of the Assembly and get it through.
And have you had any advice from the Assembly solicitors or from the Attorney General?
Well, it's funny, your colleague Kiva Archibald, who had participated in my initial cross-party meeting on this, I know she had raised the prospect of consulting with the Attorney General, which I think was fair enough and helpful enough. However, there's a bit of an issue there that we have sent it to the Attorney General. However, it's not the place of the Attorney General to advise private members, but to provide advice to the Executive. Also, I've engaged with the Finance Minister. That's just recently enough today, so I'm complaining about not having received a response or anything. But then I'll kind of maybe leave it with a ministerial colleague to check competence issues or any other issues with the AG.
Okay, and I suppose given the week that's in it, with Cheltenham on, what are the odds of getting this onto the floor of the Assembly?
There's probably a better chance than there would of picking a winner at Cheltenham, perhaps, but that doesn't say much. My name, Durkin actually derives from the Irish word for pessimist, believe it or not. But I'm uncharacteristically optimistic that there is a chance here to get something done. If it doesn't happen, we'll be disappointed. People will have been let down, but I think we're making the effort and I appreciate that other parties are as well.
Okay, well, good luck with it anyway. That's all I have to ask. Thanks.
Thanks, Pat.
I have no other members looking to come in, but I'm reluctant to say that in case others can't. Everybody speaking out there. I knew Diane was going to come. Diane, sorry, can I bring you into the spotlight?
I'm so sorry. Just very, very quickly, what do you see as the timeline, Mark?
I think at this stage.
And will you get it to the Chamber Monday? It would need to, wouldn't it?
Yeah, but don't curse me for this. I think there's the potential for a Saturday sitting next week.
Oh, Mark.
You can join via Starleaf, Diane.
Oh, dear. I was giving out leaflets on Saturday. No, that's fine. So you think that? So just run through that, how that would work.
Well, again, this will be in the hands of the Speaker and contingent on the advice that comes back from legal services. There's also already been engagement across party whips and they will re-engage as soon as we get a green light, hopefully. It could be a red light, like I said. We're currently on amber, which isn't particularly helpful for anyone, but these things do take a bit of time. It's going to take a wee bit of time, and to be fair, they're being, I think, more flexible than normal in the Speaker's and Bill's office in that regard, recognising the constraints we have here time-wise. But I think in terms of the standing orders of the Assembly, whenever there can be, or if there can be agreement reached across parties to set them aside, that can be done, and this can be done by the end of the mandate.
Okay, I will be interested, and I am of course up for a Saturday meeting. That's what it takes.
I will get you out to deliver leaflets.
Oh dear.
Okay, thank you very much. I have no other members who wish to raise any questions with you, Mark. I thank you for coming to the committee, and I wish you well in your endeavours. And the committee will now seek agreement on whether your request can be put forward. But in the meantime, thank you very much, and we'll be in touch.
Thank you, Chair. Can I stay on for the vote?
Okay, so members, can I ask, have you any further views on the request for accelerated passage? And just on that as well, and can I ask, would you support that accelerated passage? Would you support that now, if the committee could give me a view in it?
Yes. Sorry.
Yes.
Yes,
Yeah.
yes. And
Yeah.
it's a yes from John Stewart and Trevor Lunn as well. So if Mark Durkin is still listening into it, yes, we agree to put forward your bill for accelerated passage. Thank you. Item number 8 is Legacy Report 2017 to 2022, consideration of draft report. Can I refer members to pages 161 and 186 of the meeting pack for the relevant papers? Members, the bill report has now been added, and that outstanding areas of correspondence and additional comment on the programme for government and New Decade New Approach will be in the final report. I just think it's really important that we prioritise the next work of the committee, that there is a real concentration on delivering a programme for government, so that there is a Bible, more or less, that you can work towards within committee in terms of delivery. And the best way to do that for any government, and scrutinising the executive office in particular, is that you work towards a programme for government, and that hasn't been forthcoming in this mandate, and it's important. So it's good to have those additional pieces in the legacy report. So members, are you happy with the content of the report? Okay. Yeah. So forward work programme, members, on pages 216 to 220 of the meeting pack, forward work programme. Members, the final meeting of the committee will take place, we think, maybe, perhaps, next week on the 23rd of March 2022, where members will agree the committee legacy report and address any outstanding correspondence. Members, there's also outstanding invitations to the junior ministers and to the Minister for Europe. So I don't think you should wait with bated breath on Liz Truss coming to the committee next Wednesday, but there are outstanding invitations. So if you're content to note the remainder of the forward work programme. Okay. Item number 10, correspondence. Members, there are 10 items of correspondence from pages 221 to 320 in the meeting pack. 9.1 is the Independent review of Invest NI, a call for evidence. 9.2 is the Department for Communities news release, progress and strategies for Irish and Ulster Scots. Members, the following recommendations from the expert advisory panel set out plans to enhance and protect the development of the Irish language and Ulster Scots. This was referred to by the Minister last week. 9.3, Committee for Justice troubles permanent disablement payment scheme. 9.4 was the Executive Office State Apology, Victims and Survivors of Historical Institute Abuse on the 11th of March. 9.5 was the Executive Office State Apology, Victims and Survivors, and the Deputy Chair and my invitation. 9.6 was the Executive Office Draft Budget 2022 to 2025, and 9.7 was the Committee for Infrastructure, Rebated Fuel Entitlement and Fuel Duty. 9.8 was the Executive Office News Release, Permanent Secretary Appointments. And 9.9, the Executive Office Response Ad Hoc Committee on the Bill of Rights, which was probably a very weak response there as well. 9.10, the Executive Office News Release, Apology to Victims and Survivors of Historical Institute Abuse, Ministerial Statements, and that pack. So if members are content to note. Okay. Any other business? Has anybody any other business they wish to raise? Okay. The date and time and place of the next meeting is Wednesday, the 23rd of March at 2 p.m. here in room 30. Thank you.
Committee room 30.